Hello, everyone. My name is Bangani Jeranyama, and I want to welcome you to our community engagement webinar series. Today, we're going to be talking about best practices for charity board volunteers and the role of the nonprofit and public charities division within the Attorney General's office. Like I said, my name is Bangani Jeranyama. I'm a program manager within our community engagement division. I'm here with my fellow program manager as well.
Good morning, Tim Deppen.
I'm also here with a representative from our Nonprofit and Public Charities Division who's going to be helping out on this presentation, trying to give you some great advice. Do you mind introducing yourself?
Not at all. Good morning, everybody. My name is R.G. Cosentado Shapiro. I'm an Assistant Attorney General in the Charities Division.
Yes, and we really appreciate everyone taking time out of their busy schedule to be here with us. Just an FYI, if you're having any troubles with viewing the presentation or hearing this presentation, you can contact our program assistant, Jaime Gomez Diaz. You can reach him at 617-963-2541. Once again, that's 617-963-2541, and he'll help you with either viewing the presentation or hearing the presentation. Just a FYI, it's best if you log in via Google Chrome or Firefox. You'll probably get the best results on those two platforms as opposed to Internet Explorer. As well as if you want to hear us, you can do that through the computer, but it's probably best if you log in through the teleconferencing component of the presentation. Additionally, if you're experiencing any issues with the Join.me screen not being displayed, please just exit out, join me, and come back in. It should be working, and you should be able to view everything that's happening. If you have any questions throughout the presentation, please feel free to ask that through the chat function. Tim is here, and he's going to be monitoring the questions that are coming in. There should be an emoticon chat button on top. You can send that to all of us, and we'll try to answer any of the questions to the best of our ability. Some other housekeeping notes: we'll be sending out a copy of this presentation as a PDF after we've completed this presentation, so later on today. We're also recording today's presentation. We'll upload it up to YouTube, and we'll send you a link to this presentation. That'll probably happen in a week or two, but you will get a copy of the presentation. We're also going to be sending out a Survey Monkey. Please take the time out to complete that. It's about 8 to 10 questions, and it really does help us better the webinars. So before we get into best practices for charity board and volunteers, I'm going to take about 10 to 15 minutes to introduce the Attorney General's office and get you up to speed with who we are and what we do. So thank you again for being a part of today's presentation. So right there on the screen, you have our boss. That's the Attorney General, Maura Healey. She's the Chief Lawyer and Law Enforcement Officer of the Commonwealth of Massachusetts. And she actually has an interesting background because she was actually a professional basketball player before she started off as the Attorney General. She played collegiately at Harvard University and then actually played professionally out in Europe. She decided after a couple of years that she wanted to come back to the States and get involved in the legal community and get involved in public service. So she got her law degree and then eventually joined the Attorney General's office, where she was the head of our Civil Rights Division. She then went on to be a head of our Public Protection and Advocacy Bureau, which houses a lot of things from our Fair Labor Division to our Consumer Protection Division to our Civil Rights Division and many more. It's our most public-facing division, and we're going to talk a little bit about that in the future. But around 2014, 2015, when she was originally running for Attorney General, she went out to communities from Pittsfield to Hyannis and everywhere in between, and she spoke about her vision of Massachusetts and what the state could be. A lot of people were excited about what she said, but they were interested in what the Attorney General's office was, because not a lot of people understood what the Attorney General's office is, how it could help them, how could it help their family, and how could it help their community. So she created our team, the Community Engagement Division, so that we can go out into areas throughout the state, day and night, weekday, weekends, anytime that people are available and wherever they are available, to go out and reach out and try to best help and bring the resources of our office into their communities as well. So that can include things like today's webinars. It can include an in-person training to your organization or your community, and it can include other programs that we put together, like our wage theft clinics, where we go have wage theft clinics monthly in Boston and quarterly in New Bedford and Springfield to pair people who have been the victims of wage theft or workplace rights violation with legal assistance and legal guidance as well. That's just a few examples of what our office does and how we can help out. And the Attorney General's office isn't just the community engagement team or the Public Protection and Advocacy Bureau. We have 6 bureaus in our office. We have a criminal team that kind of does what you think a law enforcement agency does, right? We look into bad actors, we take them to court if need be, and we try to maintain adherence to Massachusetts general laws in Massachusetts. We have a Healthcare and Fair Competition Bureau that houses things like our Healthcare Division and our Antitrust Division as well. They look into a lot of things. They also have our Nonprofit and Public Charities Division, what we're going to be talking about today. So that division has a lot of helpful departments in there. We also have an Energy and Environment Division that looks into energy and environment issues throughout the state. Chiefly right now we're looking into competitive residential electric supply. And looking at the role of third-party suppliers in electrical supply in Massachusetts. That's something that our office is chiefly looking into. We're making sure that consumers are put first and that they are not being scammed out of fair prices for energy and environment. We have a government division that looks into things like the open meeting law and looks into municipal bylaws and multiple things as well. And we're housed in the executive team that also has our policy and government team, our communication teams, even our HR teams that kind of helps the whole office run. Again, if you have any questions throughout the presentation, please use the chat function. We'd be more than happy to answer them. So who do we serve in Massachusetts and how do we serve? One, as long as you live in Massachusetts, regardless of your race, your gender, your national origin, your immigration status, sexual orientation, or whatever, as long as you live in Massachusetts, we represent your interests and represent people who live in this state. We also represent groups of consumers that can be looking into making sure that bad actors who are affecting multiple different people are brought to justice. It can make sure that laws are open and people have accessibility to government. One other questions that we get is, hey, I've got a private action that I need to be settled in court. Can one of your attorneys or your team handle this? Unfortunately, we cannot. One of the reasons why is that we have a constitutional duty to represent State Departments, officers, and commissions in any type of legal actions. So any type of legal actions right upon them, we have an administrative law division that actually handles that. But another reason is because we have 500 people that work in our office. We have assistant attorney generals, we have legal analysts, we have paralegals, we have consumer specialists, and everything in between. We unfortunately cannot look into every type of situation, but our office does have administrative ways that we can come in and we can try to help resolve situations. We can look into consumer issues. We have mediators and consumer specialists that can call on your behalf to try to set up some type of mediation of the situation, and we can help in that type of way. How do we do that? As you'll see on the right-hand side, we have 4 major ways of doing that. I kind of look at it as 2 different tiers, right? Investigation and enforcement, that's your traditional law enforcement roles, right? Again, we have our criminal bureau, but we have all other bureaus in our office that look into laws, look into organizations and businesses and make sure that they are following the law. If there are bad actors out there, we look into them and we try to find some type of solution to that. That can be a court action, that can be a settlement, that can be multiple different things. But we also try to be very proactive, and I kind of look at that as the bottom tier. We want to let people know about what their rights, but also what their responsibilities are under the law, and let them be educated towards what the law entails before they can even break it or not follow it. So we try to do prevention work like what we're doing today, where we go and we teach people about what are their rights and responsibilities under the law. We also interact with a lot of people. We have a consumer complaint system that comes into our office. We go into different communities. We interact with people, and we take all of that information and we use it to guide us when we're looking to policy changes. Again, we have a policy and government team. We use all that information to educate us and understand what type of regulations we can change for the residents of the Commonwealth. Do we have a question?
Yep, so we have a couple questions here. One is a technical issue. The audio keeps going out and the chat is very slow. Not knowing how you're getting the audio currently, I would suggest if you're not able to hear it, you may want to try calling into the teleconference, as Bongani mentioned earlier. Otherwise, my apologies if the audio isn't working. As far as the chat going slow or the slides going slow, if it does stop entirely and you're not able to see anything, as we said off the top, suggest exiting, join me, and re-entering might be the best way to facilitate that. Again, I apologize for any technical issues. I think we're sort of close to the cap of the amount of people that we can have on our webinar. It's very well attended, and I think we're dealing with some of that coming back on us here. The other question is, how do you lodge a consumer complaint against a business? You can go to our website, which is mass.gov/AGO, mass.gov/AGO. Right on that website, one of the first buttons you'll see is to file a consumer complaint, and you can file that complaint. You can file a consumer complaint. You can file a workplace rights complaint. Many complaints you can file from there that will come through to the Attorney General's office, but the best way is to go on our website.
Thank you, Tim, for answering those questions and letting us know. Again, throughout the presentation, if you have a question, if it's something that we can help out, we're going to be answering it to the best of our ability. We'll do like that. Tim will help out, and one of the presenters will be here to answer that. But back to the Attorney General's office. Like I said beforehand, we are located here in Boston, right in downtown, near the State House at 1 Ashburton and 100 Cambridge Street, but we're also in downtown New Bedford, downtown Worcester, and downtown Springfield. But again, we don't want to just be there. We want to be in your communities. We want to be where you're at. So that can be in Greenfield, that can be in Fall River, that can be in Lawrence, wherever you're at, we want to be there, and we want to be helping you out as well. Additionally, I just want to let you know about our Public Protection and Advocacy Bureau. Like I said earlier, that's our most public-facing bureau. If you contact our office, most likely you'll be sent to someone in our PPE Bureau, and specifically our Consumer Advocacy and Response Division. They help by fighting for consumers against scams and other deceptive business practices. We have a Fair Labor Division that ensures that workers are getting paid what they're owed. We have a Consumer Protection Division. We have an Insurance and Financial Services Division that makes sure that we protect students against predatory for-profit schools. So we want to make sure that we're there, we're helping you out, and we are available to help you. So I know that we have some that's saying audio loss. Again, the best way to actually hear us is actually by logging in through the teleconferencing. The teleconferencing instructions were sent to you this morning as well. There's a number that you can log into. That might be the best way to hear it as opposed by hearing it through your computer. But thank you, everyone. That's going to be my time. But right now, we're going to get into kind of the meat and potatoes of what you want to hear about today. We're going to be talking more about best governing practices for volunteer-run boards of small charitable organizations. I want to give it up to my colleague who's going to be able to help you out. Thank you, everyone.
Thank you, Bongani. Good morning, everybody, and thank you for joining us on this webinar today. My name is R.G. Cosmetato Shapiro, and I am an Assistant Attorney General in the Nonprofit Organizations Public Charities Division of the Attorney General's Office. I'm pleased to offer this webinar to board members of volunteer-run charitable organizations, most notably the PTOs and youth sports leagues that do incredible work supporting your schools and your community. My goal is to offer you as board members suggestions from the perspective of a regulator on steps that you can take to ensure, first, that your organization successfully carries out its charitable mission and purposes. And second, that as stewards of your organization, you protect the organization's charitable assets. Without you, we wouldn't have PTOs or sports leagues. So I commend you for your dedication to your community and organization. I appreciate the time constraints and challenges you face. And in the spirit of collaboration, my goal is to assist you in avoiding many of the common missteps I have seen with charitable boards and arm you with the tools that you need to succeed as a board member of a well-run charity. With that said, I begin with a small disclaimer that the views and suggestions of this offered in this presentation are my own and not necessarily of the Attorney General's office. Basically, the takeaway is that nothing with regard to what I say here today should be construed as legal advice, but rather advice based on my experience and offered to help board members and potential board members. We have plenty of official guidance documents available on our website, and that will be given out at the end of this presentation. In the next 45 minutes or so, I will discuss a few key topics. The Attorney General's Office's jurisdiction, in particular the Public Charities Division's oversight, board member duties, in particular the duty of care and the duty of loyalty. I will also talk about common challenges facing board members, as well as steps to ensure proper board governance, and finally some resources that you can turn to for guidance. We begin with the Public Charities Division and the Attorney General's Office's jurisdiction in the charities world. Through its Public Charities Division, the Attorney General's Office is responsible for overseeing more than 23,000 public charities in the Commonwealth. Whoops, I forgot to turn to the next slide. Sorry about that. By law, the Attorney General's Office has the power to oversee the due application of charitable funds in the Commonwealth and prevent breaches of trust in their administration. What does this mean? It means, again, that the Attorney General's Office's role as regulator is multifaceted. In the charities world, our job is first to support transparency and accountability, second, to enforce the law, third, to remedy wrongdoing, and fourth, to deter bad practices, which goes hand in hand with supporting good practices by providing guidance to the charitable sector. In promoting transparency, the more than 23,000 charities that do business in Massachusetts must register with the Secretary of State's office and with the Attorney General's office, and they must file annual reports with the Attorney General. This requirement also applies to professional fundraisers. And many charities rely on donations from the public to accomplish their goals. Some charities raise funds on their own, but others hire professionals to raise funds on their behalf. Contributions may only be solicited by or behalf of a charitable organization registered with the Attorney General's office. All professional fundraisers must be registered with the Attorney General's office before doing business in the Commonwealth. The registration requirement also applies to commercial co-venturers. For example, if you have a local pizza place and they advertise that they're going to donate 10% of their proceeds to the Medford Elementary School's PTO, the pizza place must register with the Attorney General's office as a commercial co-venture. We see this all the time with Chipotle and other retail establishments. The Public Charities Division reviews registrations and filings to ensure compliance with state law. That means we review and process lots of paper, but we also work with charities to get them into compliance. In addition, we review major transactions undertaken by charitable organizations. Most often, these transactions involve a transfer of assets. Anytime there's funds that are donated for charitable purposes, we call these restricted funds, or endowments that a charity wants to transfer to another entity. We review those matters too. We review a lot of dissolutions where a board comes to us and says, hey, we don't have enough money to continue running the organization, or we really don't have enough interest and we can't get people to serve on the board and we think it's best to dissolve the organization. If an organization has assets, they need to get court approval to dissolve. The paperwork comes to us first. If the organization doesn't have any more money, we help them dissolve without going to court. We call that administrative dissolution. Finally, we publish reports and forms, and those filings are available on the public, to the public on the division's website. So that's transparency. For accountability, in order to ensure accountability, we, as the Public Charities Division, promote this goal in various ways. It ranges from informal to the formal. We speak to members of the charitable sector and counsel. We meet with these folks and other stakeholders. We ask questions. We follow up on information we learn. And while we can't dispense legal advice, we also act as a resource. We have a lot of information on our website, a wealth of information that's very helpful to providing you with guidance. And if ever you have a question, many of us are here to help. And when things go wrong, we also enforce charities law. Our goal with respect to enforcement is to support charities in fulfilling their charitable mission and to put them on the right path. And we do that through routine monitoring. We do that through informal monitoring. For example, when the board comes to us and self-reports, we may monitor the organization's progress. We may conduct a formal inquiry or a formal investigation. Sometimes we initiate an investigation by applying to the court for what's called a civil investigative demand, which is basically a subpoena for documents or, witness testimony. Sometimes we send what's called an 8L letter, asking the recipient to provide us with documents and other information. Other tools we have are anything from governance agreements with boards or offices of a charity, requiring board members to file periodic reports or issuing them a letter, requiring them to comply with the charitable laws. From time to time, we initiate litigation related to breaches of fiduciary duty or misuse of charitable funds, conflict of interest, deceptive solicitation. But our role, as I said, is multifaceted. We remedy wrongdoing by making sure that the charity is made whole, and that can be done through settlement agreements with the wrongdoer in civil proceedings. But most often, we actively pursue opportunities to deter bad practices and support good practices by providing board members with guidance, such as this webinar today, and guidance on our website and in community outreach presentations. In a little while, I will discuss board members and their obligations when serving on the board of a charity. But before I do that, I think it's very worthwhile to address what it means to be a public charity. In Massachusetts, there's a three-pronged definition, that the entity must be not-for-profit, have a charitable purpose, and that could include, it most often includes educational, scientific, religious component, and three, there must be an indefinite class of beneficiaries. But for our purposes here, all you need to know is that public charities vary in size, from the smallest PTOs and youth sports leagues and homeless shelters to the largest hospitals, healthcare systems, and universities in the Commonwealth. One of the biggest mistakes that we see board members of charitable organizations make is not understanding what the nature and scope of fiduciary duties are. In legalese, board members are fiduciaries. This means that they are stewards of the charity. They are entrusted with safeguarding the charity's assets and acting in the charity's best interests. Board members are, therefore, the first line of enforcement.
And I just want to let everyone know that if you have any questions throughout this presentation, we know that there's a lot of different things that are coming at you right now. Please use the chat function. Tim is here again to answer any of your questions. I know it might be a little bit slow right now. That's because we're almost reaching capacity, but would be more than happy to have Argy answer any of your questions.
Thank you, Bongani. And I know I've tried to simplify it so that it's not as complicated, because it really isn't complicated. And as we go through the presentation, you'll see that what really matters is that you ask questions and you use common sense when you're serving on the board of a charity. Because board members govern the charity and set policies. Some board members may take care of the day-to-day operations of the charity, but really, the duty by law, there's two duties, and these duties that board members owe the charity, the duty of care and duty of loyalty, can be simplified to asking questions, putting the organization's interests first, and disclosure and discussion. And you'll see what I mean. The duty of care is the first duty, and it requires directors and officers to perform their duties in good faith in a manner they reasonably believe is in the best interest of the corporation, and with such care, this is by statute, the language in the statute, as an ordinarily prudent person in like position with respect to similar corporation would under similar circumstances. What does this mean? Simply put, it means that board members should know what's going on. That means asking questions about the charity's finances. It's okay if you rely on accountants and other experts, but as board members, you should know how to read an audited financial statement. The goal with respect to knowing about the charity and how it's doing financially is to ensure that it's fiscally sound. Board members should ask questions about the charity's operational functions. How does it run its programs and activities? How does it generate revenue, its expenses? Board members should attend meetings, review reports, review the Form 990, Form PC. These are the filings that, the documents that are filed with our office. And you should review other forms that the IRS requires a charity to file in the Secretary of State's office as well. Board members should monitor the charity's activities. Do the charity's activities promote its charitable purposes? How can the charity generate revenue? How can you increase community interest? How can you solicit donations and entice more volunteers to help further the organization's mission and purposes? Board members should ensure that the charity is complying with the legal requirements and regulatory requirements. You may say, well, gee, AGO, Attorney General's office, I'm not an attorney. I don't have any legal experience. How am I supposed to know what my legal and regulatory obligations are? Well, the good news is that you don't need to be a lawyer to serve on a board. What you should do is you should bring your professional and life experiences, your background, your inquisitive nature to the table. If you don't have training or experience, all you have to do is ask questions about the basic requirements for your organization. Board members should implement policies and procedures. This is very important, and we can't stress this enough. Every charity should have policies and procedures in place on issues related to conflict of interest, and other scenarios requiring disclosure to the board, which I'll discuss shortly. Every charitable organization should have checks and balances for custody of funds, for paying bills, approving expenditures. Board members should periodically review and revise policies and procedures. Board members should document board processes. For example, if you have meetings, create agendas, minutes, some description of what happened at the meeting and what took place with the board vote on any decision-making that you went through. Board members should have a process in place for assessing their own performance and their composition. But most importantly, board members must safeguard the assets of the charity. And the only way to do this is to know what's going on. The takeaway from this is that a board that's engaged and knows what's going on will go a long way towards ensuring a well-run, robust charity, and a charity with a reputation for being solid, because a charity's reputation is critical to its financial stability. In a community, the public's willingness to donate to a charity is tied to public perception, right? Simply put, if a charity is poorly run, the public will not trust the board with donated funds and won't donate to that organization.
So you said a couple questions here.
Sure.
First one I can take, which is, will the slides be available at the end of the presentation? Yep, everyone will receive a copy of the presentation at some point after this presentation. And then one question is that if a charity is registered with the Secretary of State's office, must the 501c3 organization still register with the Attorney General's office, and how do they go about doing that?
So if you are registered with the Secretary of State's office and you are 501c3, more than likely then you meet the test in Massachusetts, the three-prong test that I just briefly touched upon before. If your support, your donations come predominantly from the public, then you are required to, and you solicit donations in Massachusetts, you are required to register with the Massachusetts Attorney General's office. And you do that through, there at the end of the presentation, there's a resources part that we list the various websites, and you can go on to the, but most importantly, you can go on to the Attorney General's Public Charities website, and there is guidance there on how to do so. And you can always call us. Our compliance analysts will walk you through the registration process. Any more questions?
That's it.
Okay. All right. I'm going to talk about the second duty, which is the duty of loyalty, and that requires board members to act in a good faith in a manner you reasonably believe to be in the organization's best interest. So what this means is that you must put the organization's interests first, best interests first, and you do so by avoiding conflicts of interest with the organization. A conflict of interest can mean a couple of things, but basically it means it arises when a board member or officer has a financial interest in the transaction that the charity is negotiating. I'm going to give you an example. You're the treasurer of the Medford Little League, and your wife owns an apparel store, so your wife's willing to give the Little League a discount on sports apparel if players order the team's baseball shirts from her company. This is a conflict of interest because your wife and you stand to gain financially from the transaction, and it's not necessarily illegal if it's managed properly, the conflict of interest. And I'll talk about how that can be done in a few minutes. A conflict of interest can arise if you, as a board member, steer business to your firm, friend, or family, when there's loans or compensation or self-dealing. Sorry about that. Okay. So managing conflict of interest. The way to manage a conflict of interest, and it's not necessarily illegal, is to disclose, discuss, and manage. So when you as a board are meeting, you identify what does it mean to disclose, discuss, and manage. First, you identify the conflict. So let's say you're on the board of a soccer league and you have, let's take the apparel example, and your friend owns a clothing store and there's a discount that your friend's willing to give the team if the team orders the team shirts from them. The disclosure part is you tell the other board members that, hey, listen, I have this friend and this is the offer. You tell them about that. But then you recuse yourself. What does recusal mean? You leave the room and let the other board members discuss the matter and take a vote on whether they want the organization to do business with your friend. The board should also document their discussions about the conflict and document the vote. So even if they decide to go ahead with the transaction, as long as the conflict is vetted and discussed and documented, and the board knows what's going on, the duty of loyalty to the charity will have been preserved. So disclosure, discuss, and manage. That's the first way to manage a conflict of interest. The second one is very important as well, is to have a conflict of interest policy and to document that the board has received, reviewed, and acknowledged the policy. It's also important to consider periodic disclosure of outside interests and relationships and review of written disclosure materials. Every couple of months or, once a year, review the disclosure, the conflict of interest policy, review the disclosure of outside interests. Just take a moment and make sure that, you have everything in place, the systems and processes. Another important step is document discussions, document the decision-making by a disinterested board. So the person who has the conflict, it's often better if they leave the room and let the other board members discuss, and the other board members would be disinterested. I can't stress enough how important it is to document the decision-making process and to demonstrate that the board considered the important factors and made reasonable decisions. One example that I can give you is Charities executive board purchasing an insurance policy from the charity from a company for which one of the board members works for and failed to follow their internal policies for conflict of interest. So if you have a policy in place but you don't follow it, that's a bit problematic. Okay. Some of the common challenges that we see, in addition to managing conflict of interest, are, and that falls in place with the lack of structure and processes. If you don't have a conflict of interest policy, if you can see the screen on the right, where we talk about lack of structure and policies, if you don't have policies, you don't have procedures in place, it's important to create and implement minimum standards for internal controls and monitoring. But it's also important, fundamentally important, to have checks and balances for finances. Determine who is, for example, we do this at home, at work, and in daily life. We have processes and rules, right? Budgets and whatnot. But for finances in particular, it's critical to safeguarding charitable assets if you have a system in place. You should designate a custodian of funds, people on the board who are authorized to write checks and deposit funds. It's important to have more than one person do this job. You should designate how the charity will keep track of donations. Is there a system in place for documenting and tracking revenue from programs that your organization hosts? How do you track donations that are made to your organization from the public? What fundraising efforts will you pursue to bring in revenue? Is there a system in place for approval of expenditures? Who approves paying the bills? It's a good idea to have different people do this task than the person who writes the check, perhaps, or has custody of the funds. It's all around a good practice to have different people have oversight over anything related to money. The prime example, as I mentioned before, is having more than one person who can write checks. We once saw a charity where receipts were kept in a book, shoebox, and you know, that's very difficult because you can't keep track of. It's very hard to keep track of finances when you have receipts thrown in a shoebox. So it illustrates the importance of having some sort of structure and process in place. You already talked about conflict of interest, so I'm going to move on to another big, problem that we see is founder syndrome, and that is when you have a small charity and a board that is often guided by a charismatic and visionary, committed founder who acts as though he or she is the founder or the source of all knowledge. Without any processes or procedures in place, it's easy for boards or officers to be complacent. Oftentimes the founder can be convincing when, he or she says, well, we do things this way, or we've done it this way for many years, or one example that is the founders of a charity are a husband and wife team, and they are the only two people with signatory authority on checks, and those same two people control the books. The other officers and directors are too disinterested or distracted to review the financials of the charity appropriately. So as a result, the duo, the husband and wife team, began using funds for personal expenses, restaurants, knitting supplies, and nobody noticed. If appropriate structures were implemented requiring additional oversight over who was in charge of the books, who was in charge of signing checks, who was in charge of paying bills, who was in charge of depositing funds, the board officers would have had a system in place to rely on for preventing misappropriation of charitable assets. Another example is a charity on the North Shore that had slim staff coverage cover the holidays. There was no protocols for intake or deposit of donations, and that made it easy for an employee that covered the office alone to deposit donations received in the mail into his account. The challenges that we see also include a distracted, disinterested, or comfortable board, or a weak board. The bottom line is that you can cure these ailments by having a board that's informed, a board that's independent, and solid policies and procedures that are followed. With that said, what are the simple, common sense steps that you as board members can take to ensure proper board governance? One, be informed. Attend board and community meetings. Before each meeting, ask for and review agendas, detailed information on matters requiring board member vote, and other pertinent reading material. Two, review the charity's governing documents. That's part of being informed. And ask questions about anything you don't understand. Study the charity's mission and goals and consider effective strategies for accomplishing both the mission and goals of the charity. Understand the unique operational, legal, and financial issues that the charity faces. And finally, review and ask questions about the financial statements and the reports from the treasurer, the charity's annual Form 990 and Form PC returns. Those are the PC returns are filed with our office, and any audited financials that the charity may have. So the first was to be informed, to ask questions and understand what's going on. The second is to be independent. During meetings, you ask questions, respectfully listen to others, consider the advice of professionals, and make decisions that you believe to be in the best interest of the charity. Don't be intimidated by other board members or officers or other individuals who may disagree with you. Make your decisions as a fiduciary of the charity. your own decisions. Encourage growing the board and establishing term limits. That's a way to avoid allowing the board to be dominated by any individual or small groups of individuals. Some boards have staggered board memberships and terms on which boards can serve. So we have be informed, be independent. The third is implement proper internal controls. And I know that this may be repetitive, but I think that it's important to talk about it and revisit some of these points because really it boils down to having the right structures in place, making independent decisions, and asking questions. And the implementing proper internal controls is important because, as we said before, the charity should have its own bank account and should which will help ensure that charitable funds are never mixed with personal funds. You should ensure that monies that the charity receives and pays out are deposited into and paid from the charity's bank account. You should establish and follow clear protocols for accurately tracking expenses, revenues, and charitable contributions. You should establish and follow a clear policy regarding document retention, including copies of invoices and checks, receipts for cash deposits, withdrawals, credit card or debit card purchases. And you should document and review the delegations of signatory authority every year. It's a good idea every year to just sit down as a board and discuss, right, should we change who can sign checks and maybe appoint another person and maybe do a rotating system, whatever works for you. The fourth thing that is important to ensure that a charity is fiscally sound is to implement checks and balances. As I said before, consider requiring signatures from 2 designated board members for checks that exceed a certain dollar amount maybe, or require an internal written record that the payment has been approved by another person, in addition to the person who signs the check. In other words, that there's a check and balance on, writing checks and paying expenses. That's very important. Consider designating a different person other than the one who signs checks to manage the charity's financial books and approve expense reimbursements. You should consider maybe appointing more than one person to collect, count, and deposit cash. Consider appointing officers to alternating or rotating roles. Be vigilant, and this is very important. Being vigilant about the charity's income and expenses. If you have a debit card or board members who have used debit cards and make other purchases, they should be able to substantiate those purchases with receipts. Beware of vague responses to questions about cash withdrawals. You should implement a comprehensive conflict of interest policy, as I mentioned before. Because a disinterested board is very important. Designate a board member in charge of working with the treasurer and clerk to ensure that records are properly maintained and that the proper filings are made with the various agencies in government, including our office. And finally, one of the most important pieces of suggestions that I could make to you is, if you have a major transaction that's coming up, consult with our office. There are certain major transactions such as mergers or sales or distributions of a large portion of a charity's assets and dissolutions that are subject to specific legal requirements. And many of those transactions require approval of the Attorney General's office and/or maybe the courts. Please contact the Attorney General's office if you have questions about whether those requirements apply to any particular major transaction. In particular, Please note that a charitable corporation in Massachusetts cannot simply distribute out all of its assets and dissolve. Board members retain their fiduciary duties to the charity until the charity is formally dissolved through the courts and/or the Attorney General's office. And finally, take initiative. Monitor and review the charity's practices and policies from time to time. Consult with other charities and with the Attorney General's office on evolving best practices. Consider other ways in which board members can fulfill their duties of care and duties of loyalty to the charity. So what are the takeaways from this webinar? There's just a few, right? The best way to meet your fiduciary obligations is to be engaged. Ask questions. Do your research. Ask questions, again, and come to your own independent conclusions based on the information you have gathered. Disclose any conflicts. Discuss them with the board and manage involvement, including recusal, i.e. leaving the room if it's appropriate. Put policies, procedures, controls in place to avoid things like fraud, opportunity, trouble with founder syndrome, a complacent board, and restricted fund tracking. Structures are protocols for managing expenses, like we talked about before, revenues, retaining receipts for cash deposits, keeping copies of invoices, signatory authority, circulate agendas and document discussions, including recusals. All of these things are important to ensuring that the charity has something to go to when there's questions that arise about whether certain things should be done. In a sense, it'll provide you with a system of checks and balances to guard against mismanagement and conflict of interest and prevent fraud. We are here as your resource. As you can see from the screen, you can give us a call if you have any questions or doubts. We can't dispense legal advice, but certainly we can act as a resource for you. And I'd like to thank you for listening in on this presentation. I hope that it was helpful to you as you continue your service as stewards to your organizations and communities, and that you consider us a resource. If you have questions, give us a call. We're happy to answer your inquiries. I appreciate your time today, and thank you for listening in.
It looks like we've got a couple of questions, so we're going to ask everyone to stay on the line.
Yep, so we have a couple of questions here. One is, do we as an office have any recommendations about what size a board should be and how often that board should meet?
So in on our website, there's a guidance for charities, and I believe in our guidance, the board should be more than, it depends on the size of the organization, right? If you're a small charity like a PTO, really, it should be more than 2 people. But depending on obviously, because we suggest that more than 2 people should have signatory authority, right? The more the merrier is, I guess, my response to that question. Because we talked about founder syndrome before. We talked about how important it is to have checks and balances. That could include other people with oversight over who writes checks, who approves expenditures, who. And so it's important to have a couple of people on the board. But I would check our division's website and go through that guidance and see what that tells you, because then you can make a decision as to what's appropriate for your organization.
Another question we had, and this is going off of the registration that we were talking about a little bit earlier. Once you submit that registration paperwork, do we know how long it takes before that's going to show up on our website, the Attorney General's website?
Well, I mean, I can't tell you, I can't give you a definitive time, but it does take, we process over thousands of registrations, so, and we have lots of paperwork that we do process, so it takes us a few weeks. So I hope that answers your question.
Yep. And one last question we have here, will the slides be available for later viewing and or the entire webinar so we can point folks to it?
Yep, so we are going to be sending out a PDF copy of the presentation to you today with additional resources as well. We've recorded today's webinar as well. That will be up with probably in a week or 2 weeks, but we will send a link to that. It will be on our office's YouTube page. We'll send a link out to that once it is finalized to everyone who is registered for the webinar today. Yeah. So everyone, we're going to be here for about 5 more minutes. If you have any other questions that you would like us to answer, you can send that through the chat function. We'd be more than happy to answer that. I believe that we have some other questions right now. You said you had a question?
Are there questions through the chat feature?
Sure, yeah. Do you?
So, let's see. There's a couple of questions that some folks had, and one is, can I speak to the compensation of board members? Example, bookkeeping, registrars. Am I?
No.
Yeah. Well, so the presentation today was targeted to small charities run by board members who are volunteers who do not get paid to serve on the charity in whatever capacity they're serving on. But I would check the guidance on our website and see if that doesn't speak to your question, then certainly give us a call. But it depends on the size of your charity. I don't know what the size of your charity is, registrars of sports organizations. That's something that you're going to have to decide as a board on whether you want to compensate or not. Another question that I had was, we would like to have our board, okay, well, I think we fixed the sound issue, right? What are the requirements for notice of regularly scheduled board meetings? I'm not sure if the guidance has any, if we, again, I would look to the guidance on our website, but it's a very good idea to have regularly scheduled board meetings as much as you think you need it as a board. Some boards have it. It depends on the size of your organization. Some boards meet once a month. Some boards meet once every 2 months. Whatever works for you. But as I said in the presentation, the general idea is it's always a very good idea to talk with your other board members. So if you need more meetings, have more meetings. If you need less, have less. It depends on what you guys are discussing. The more the merrier, but it's up to you. And I would, again, double back with our resources and guidance on our website. Another question is, where do we start when only one person can write checks and we need to terminate said person? Well, that's a personal question, and I would generally circle back to the theme of this presentation is that it's very important to have more than one person write checks for these reasons, and these are the factual scenarios that can arise, unfortunately, because the big thing about having checks and balances is that it gives the charity something to fall back on to help prevent fraud. Many of you folks are maybe familiar with the fraud triangle: motive, rationalization, and opportunity. You can't control or know the pressure that other people are under, and you can't imagine how that pressure could lead them to rationalize taking money from the organization, but you can control whether or not your organization provides the opportunity to divert funds without detection. And all too often, charities don't implement simple controls that can dissuade someone under pressure from even thinking about taking money from the charity. And we've, these factional scenarios can arise if none of these processes are in place. But that's a question. That's a question that's a very difficult scenario to undertake. But the best interest of the charity come first, with the duty of loyalty and the duty of care. Who can I contact regarding liability insurance for board members? I would look I would look to our guidance, but liability insurance, I think, is something that's you call the insurance company, and I think you can shop around for insurance. I would suggest starting with the various insurance companies and seeing what they have to offer. But at the end of the presentation, this is the resources page that perhaps you should consider. I would check with the AGA's guide for board members and then shop around and see if the various insurance companies offer policies. Is there a state regulation on how the board of directors must be structured? For instance, can one develop a CEO-driven board? The composition of the board of directors, look to the guidance, our guidance for board members, and it'll give you a general overview of board composition. But typically, you designate the board. Each organization will do what's suitable for them, but the main takeaway from this presentation is people in designated roles should have, oversight with respect to other roles. I can't speak to what the regulations are because each organization is different. But again, I would suggest consulting our guide. And yes, this presentation will be available. Right,
we'll be sending this presentation to everyone who is registered for the webinar. We're also recording today's presentation. We're going to upload that up into YouTube. That'll be available in about a week or two. We'll also send that out. But today, you'll receive this presentation with additional information. We also will send out a survey. If you do not mind taking 1 to 2 minutes to fill that out, that would be great.
We really appreciate it. And again, the website that I'm referring to in this presentation is the Public Charities website. At the top of the resources slide, you will see www.mass.gov/AGO/charities. And if you have any questions, again, feel free to give us a call. We'd be happy to answer questions. And thank you very much for your time. And I hope that this helps, and I hope that that you your takeaway from this was good, to ask questions, be informed, put in checks and balances, et cetera, et cetera. Thank you.
All right, everyone, we're going to put the chat on mute. If you have any other questions, we'll be here for about another minute or two. Last chance for any questions. So thank you again for being a part of our webinar today. Really appreciate it.